Any mention?
Please, Your Lordship. Item number 20, my Lord. I want to withdraw it with a liberty to file fresh, my Lord.
Krishna Mohan Rava?
Yes, my Lord.
Why you want to withdraw it?
No, because money matter with bank, there some consultation is there. If they will not do, again we will come to the.
It's a request submit an instruction. Please, if you love to withdraw this petition, I will liberty to file a fresh advice. Mr. Hassan here on the other side. Hassan has no objection.
For this bank, my lord.
Yes.
23.
Accordingly, matter stands closed on withdrawal. Will liberty as prayed.
Yes, Master.
Hello.
Yes, sir.
Lordship, I beg to mention item number 18 and 25. In this 18, your Lordship has asked the parties to file the list of dates and the gist of the synopsis of the case. So I'm in the
Where's the list of dates?
Lordship, I'm in the process of filing. Kindly give me time till Wednesday, I'll file it.
Yes, Mr. Kharsi.
Yes.
Yes. I have already filed the.
You have no objection?
Till
Because it's
Wednesday,
a
your
long
Lordship.
long
is in the
litigation,
process.
that's why
Yes,
it's not
yes.
list of dates necessary. Yes.
I'm in the process of.
Then, but
Kindly till Wednesday.
I'll give you 3 weeks time.
Okay, Lordship.
Yes.
25 also, your Lordship.
18, 25.
Yes, your Lordship. Much obliged, Lordship.
Please, Lordship. Lordship, I beg to mention items 16 and 17. These are connected, my lord. Mr. S. is on sanctioned leave, Lordship.
You are here.
I'm not very well versed with these matters.
I've seen you're arguing most of the matters now.
Not the
Only small
Nokmaship.
matters Mr. D is arguing.
Nokmaship matters, my lord. I really don't have much idea.
Yes.
16, 17, my lord.
No objection.
No, sir.
As well as, my lord, they're also there in item 30, my lord. That is also for district council.
3 weeks, 30.
30, Lordship. Abdul Samad.
Sir, pass.
You're there also?
Lordship.
3 weeks. Yes.
I also have similar prayers for item 22 and 24, my lord.
Where's Mr. D gone?
He's out of
On
station.
vacation?
No, my lord. He's gone to the Delhi.
No objection?
No objection, Your Lordship.
3 weeks, 3 weeks. Yes.
22 and 24.
23?
No, my lord. Obliged, Lordship.
Your Lordship, I beg to mention item number 32, Your Lordship. Your Lordship, I pray that some more time may be given, Lordship, for us to prepare the matter, Your Lordship.
Kampung, no, what is it?
Oh,
Kennedy.
32, Your Lordship, Kennedy.
Mr. Karunaram? You have objection?
No objection, Lordship.
4 weeks.
Lordship,
Yes.
this
Highly obliged, Your Lordship.
may please, Lordship.
I would like to mention item number 27, Your Lordship. Senior Advocate Mr. Paul is out of station, Madam.
Where's the other side? You informed them?
No objection, your Lordship.
4 weeks.
Your Lordship.
Yes.
Please, Your Lordship. Your Lordship, I beg to mention item number 21.
Manikdhar.
Conducting counsels on sanctioned leave, Your Lordship.
Petitioner, Lordship.
3 weeks, yes.
Your Lordship, I beg to mention item number 23, your Lordship. Conducting counsels on sanctioned leave, your Lordship.
Who?
S. Kumar, your Lordship.
3 weeks, okay, yes.
May it please your lordship. Lordship, I beg to mention item number 19.
Mr. Noklau is a rare visitor. You should at least give him the courtesy of having a hearing.
Lordship, I agree, Lordship.
Then,
Lordship, this was a part matter, and Lordship, we were supposed to get some instructions. I'm still yet to receive some
what instructions?
regarding the salary of the petitioner and whether she had given any written instructions, and
Is
also
some urgency, Mr. Noklau, this matter?
No.
Okay, then. This one will list it, yes, after 2 weeks, if possible. Yes.
Lordship,
I'll request Ms. Karwana. Yes. Wait, I don't hear about offence. Sastram 26, 28, 29. Totally. Totally. Yes.
Supplementary list, item number 1.
What is this, Mr. Khera?
Lordship.
Yes, you want to say something?
Lordship, the Advocate General will be appearing in this case.
Appearing, my lord.
Okay.
The issue is very short one in the sense, my lord, that the my learned friend has challenged the
So let him start, let him open his case. Yes. What do you have to say, Mr. Khera? What do you agree with?
Lordship, I am a lessee by virtue of a registered lease deed dated 19/8/2014.
Okay.
This land was taken on lease by me from a clan, Hasha clan, for the sole purpose of conducting mining activities over there. I am engaged in the trade of mining. Now, once I had taken the lease, Lordship, we had applied permissions for mining, out of which certain of my permissions were granted and certain were rejected. Now, the ones which were rejected, it was pointed out that my land is overlapping with the land of one Shri Telangpede. Now, being astonished with this overlapping issue which had come up, we had written to the DFO. As the initial stage when we apply for a mining permission, we apply to the DFO for a non-forest land clearance certificate. So, in his, we had written to him once we received a communication in respect of 2 of our permission applications that there is an overlap with one Shri Telangpede. Now,
No, you written to whom? To DFO?
the DFO had communicated back to us that our
Right.
applications are being rejected because there is an overlap.
Okay.
And until the matter has been resorted and solved between the parties, the application will not be considered. So we had written him that we have a registered lease deed which was submitted at the time when we had applied for the application. And we also wrote to him that pending this resolving of the issue, please do not process anybody's application. Now, going ahead, Lordship, we did not receive any positive or any authoritative reply from the DFO.
Yes.
I'll draw your Lordship's attention to annexure 19. What has happened, Lordship, post that?
Page
90. Page 90.
90.
90.
Yes.
At entry number 2,
Yes. Maxing. What's this?
Lordship, the name of the licensee at column 2,
Yes.
it says that the application for Shri Telangpede is being processed
Okay.
at the advanced stage. Now, if I may draw your Lordship's attention to page number 33.
What is this? Google map?
Lordship, this is the map demarcating the extent and the boundaries of my land.
Okay, Mr. Kira, what do you want now?
Now, Lordship,
in most
what has
states.
happened? I'm going to it, Lordship. If I may redraw your Lordship's attention to page number 31.
Yes.
Schedule of my land. Lordship, east boundary is Kolagaon River.
So it's right, Mr. Khera. Like, okay, fine, you might have a lease deed. Now, what do you want in this writ petition? You know that we are in writ jurisdiction. We're not in civil jurisdiction. Like, we can't
Lordship.
go disputed facts.
Lordship.
Yes.
Now, Lordship, what has happened is, if I can have your Lordship's attention to page number
'You're not prepared.
68. Lordship, I'm prepared. Page number 68 and page number 76.
Yes.
Now, Lordship will see the overlapping at page 68. Lordship, I'm sorry, page 63.
Sixty 63 again is the Google map.
Lordship, this map is not ours. This map was given to us by the DFO in his letter of rejection. If Lordship would see the preceding page, page 62. If I may, Lordship.
Yes.
It says, with reference to the above, it is to inform you that this office, while processing your application for forest clearance for the proposed prospecting lease on limestone for an area of 40 hectares at so-and-so place, it was found that your proposed area, as per GPS map, overlapped Google image enclosed with the PL area limestone 20 hectares of Shri Tailang Pede, ML guarantor of so-and-so place. I
You mean
regret...
to say that these lessers of yours, they've leased the same property to two
Lordship,
different people?
yes, Lordship. And in respect of this, we filed an RTI
Yes.
in the office of the sub-registrar, which has stated that the lease of Tailang Pede was registered in the year 2020.
Okay.
Now, Lordship, it's interesting to note, Lordship, in this overlap at page 63,
Yes.
the overlap is on the eastern side
Yes.
of my boundary. Now, my boundary is the Kolagaon River, which is also apparently visible in this map sent by them.
Yes.
My lease was registered in the year 2014 in the office of the sub-registrar. Now, if
Then I'm afraid by writ it's be difficult to us to adjudicate this matter.
Lordship,
You'll have to seek other remedy.
but Lordship, if his application is being processed for mining at this stage and he gets the permission,
Nothing can be undone. You can go for civil remedies. Now, there's a Registration Act, correct?
Lordship,
Now, is there any Revenue Registration Act or not for cancellation of a deed?
Lordship,
If there is, does the Registration Act prescribe a remedy for cancellation of a deed?
Lordship,
Does it or does it not?
it does, Lordship.
It doesn't.
Lordship, I'll have to file a title suit
Yes.
for cancellation of the deed.
Yes, for cancellation, for any other supplemental, any things that will be done on the basis of any document registered which you contest, which you seek cancellation.
However, Lordship, my instant apprehension is that the same DFO's office who writes to me that my application cannot be processed because there is an overlap has not used the same yardstick. He's gone ahead in processing the application of Shri Tailang Pede.
Yes, what does the Advocate General have to say? I understand your difficulty perfectly. The only thing is that whether this is the right forum or not. Mr. Khera, you are well aware. Yes.
Under Specific Relief Act, Section 31 and 34, the
Yes.
remedy of petition that lies before the civil court, where he can go for injunction, he can go for declaration.
That's what this court only observed.
Prayer before your lordship is to direct the registrar to cancel the registered deed.
We have seen that, Mr. Kumar, that is this pray won't be sustainable in the writ proceeding. Yes.
So therefore, we not, my learned friend can approach the civil court, and because it's a title dispute between two private parties, it's a private remedy and it's a remedy, public remedy, that is my thought.
Has that concerned person been made respondent?
Yes, Lordship. Lordship,
Yes. No, let him continue. Yes, sir. Yes, sir, Mr. Kumar. Anything else?
See, to only see section 31 and 34 of the Specific Relief Act, which gives the remedy to the party, 31 and 34 of the Specific, when cancellation may be ordered.
There are many decisions in this point.
Yes, Your Lordship, and it is on 16 SAC 767 is judgment 31 is there.
Yeah.
Any person against whom a written instrument is void or voidable and who has received a sentence of such instrument if left outstanding may cause serious injury may sue to have adjudged void or voidable, and the court may decide to adjudge it and order it to be delivered and cancelled. So power to cancel the lease deed is with the court, not with the registrar.
Exactly. Registration Act does not provide for any provision for cancellation. It's only after you get a decree from a court, then the registration authorities will act accordingly.
Page 22, may kindly see page 22 of the prayer mirror. Page 22, because it is
the writ petitioner is seeking direction from this honorable court to the registrar, my lord, to cancel the impugned lease deed dated 16/6/2020. So that relief my friend can take from civil court only. He can approach, he can withdraw and approach this.
Lordship, I have also prayed that the application of Shri Telang Pede, his process be stayed.
See, Mr. Khera, if the whole basis of your contention is on a mere main prayer is for cancellation of the registered document, and no matter how much under 226 this court might want to help you or give you any relief, it's not possible because disputed facts have been brought on record. Correct? Number one.
Lordship.
Number two, we have alternate efficacious remedy. Correct?
Lordship.
And so Registration Act does not prescribe any form of cancellation. This court cannot direct sub-registrar to cancel any instrument.
Lordship.
So that is the thing. So your remedy lies elsewhere. But anyway,
Lordship, keeping the registered deed, the dispute over it aside for a moment, we see, if we come to Lordship, page 86.
You feel that it's been arbitrary action as part of the
Lordship, we had written to the sub-registrar an application seeking clarification as to the matter, and we had referred to the letter of the DFO wherein my application was rejected. Now the second information that the sub-registrar has provided, sub-registrar states that...
Where is that? No specific file.
Page 86. Yes, Lordship. His sub-registrar states that no specific file has been opened. Type copy is at page 87, Lordship, for a clear view. And goes on to state that no progress has been made since the matter is time consuming. This was in the year December.
Where is that time consuming?
Lordship, page 87. No specific file have been opened for the specific case. However, the same is under cross verification by the office of the undersigned, and as the case is quite time consuming, therefore no progress has been made till date. And till date, Lordship, 7 months have passed. There is no progress. Now, Lordship, page number 76. Page 76. There is again, they have shown that there is an overlap in my land on the eastern boundary.
That's all right, Mr. Ray.
Now, Lordship, let us see the letter which the DFO wrote to us, rejecting it. Page 68.
Yes, that we've seen that earlier, correct?
Lordship, page 68. The DFO writes, it's the type copy, Lordship. If I may. Lordship, the DFO writes, with reference to the subject cited above, it is to inform you that this office is not the competent authority to settle land dispute matters. Secondly, non-forest land certificate issued by this office does not confer any right of ownership over such land to any individual whatsoever. The purpose is purely to identify status of the land as to whether forest or non-forest as the case may be. This office-wide letter number under reference has brought...
Can I show another one? Where has the mining... the progress or process been, how, where has it reached? Is it on the verge of being granted?
Yes, Lordship, page 90.
Page?
90.
Is that correct? No, 90 is a...
Page 90, Lordship. Entry number 2.
Okay. I'm ready to...
This is the letter which has come from the Union Government, Lordship.
Yes.
where they are saying that his files may be processed ahead now. Now this is in respect of my land.
Yes.
So if this application is processed ahead in respect of my land, Lordship, it will be absolute
That is why
illegality.
it's almost imperative that you go to the civil court at the earliest. That's
Lordship,
the only thing, Mr. Khera.
we will approach
The thing is that the thing is that you understand the court also made his mind clear. Under 226, very difficult.
Lordship.
We cannot use a discretion in such a manner.
Lordship.
Anyway, you take down.
Lordship, we will approach the appropriate civil court for
How long will it take to approach it?
Lordship, will take at least, sir, Lordship, 4 to 6 weeks to approach.
I have no difficulty because there is a private party here and whose interest is because probably if you're working with the.
No, one thing, Mr. Kumar, the way the authorities have gone about, right, in writ jurisdiction we cannot interfere, but I think the way they've gone about it, I mean, this person, if he has a valid lease, and if there's overlapping there, whatever, it demands that, that should be settled first before anything is processed. And just because he's come in a wrong forum doesn't mean,
Because I am not favoring either private.
Yes.
It's not my.
Take down, yes.
But only limited prayer is Milord, that the petitioner can go before civil
Yes.
court, Milord. We have no difficulty.
Right.
In that.
Yes, take down her, Mr. N. Khera, Learned Counsel with the petitioner, and Mr. A. Kumar, Learned Advocate General, with so and so for the respondents number 1 to 8.
Lordship, 1 and 2 are the union. 1, 2, 3 are union.
1 and 2, Dr.
1, 2 and
3. Learned DSG for the respondents 1 and 2, and Learned Advocate General for the 1, 2 and 3.
1, 2, 3.
1, 2, 3.
Union.
And Learned Advocate General for the 4, 5, 6, 7.
4 to 8.
8, yes. Stop.
Lordship, number 10 also.
4 to 8 and 10, okay. The grievance of the writ petitioner who has come before this court by way of the instant petition is that mining permissions, it's on licensing or permissions or leases?
Lordship, it's a license to mine.
License and leases have been processed in spite of his protest with regard to the situation of the proposed area, in as much as it is stated that he is in possession of a lease which overlaps the said area which is proposed to be allowed, which is in the process of being issued mining leases. Next part, the prayers made out in the writ petition is for cancellation of a lease dated 16/6/2020, executed and registered at the office of Sub-Registrar, Southwest Kassil District, Makurad, between a certain Hasha clan and the respondent number. His respondent number?
11.
Respondent number 11. Respondent number 11. Stop. It is submitted by Mr. N. Khera that this lease is subsequent to the lease which has been entered between the same clan.
Same clan.
Between the same clan and the writ petitioner, which was executed in 2014. Stop. He therefore prays that the subsequent lease be not given effect to, or be cancelled, or the prayer must be that be cancelled. The prayers made out it will be cancelled, and that the concerned respondent government authorities be directed to reject the applications for mining permissions and for grant of lease to this respondent number, the Telang Praise respondent number
11
for the area which is under dispute. Stop. Next paragraph. Mr. A. Kumar, Advocate General, has raised serious objections with regard to the maintainability of the instant writ petition. Firstly, that the same involves disputed questions of fact, and that alternative efficacious remedy is available in the form of a civil suit for cancellation of such instruments. So, and further that the Registration Act of 1960, 60 right, Registration Act doesn't provide for such cancellation. Stop. I've heard the counsel of the parties and considered materials on record. It is correct that the prayer as made out in the writ petition is unsustainable, inasmuch as it seeks cancellation of a lease deed wherein alternate remedy exists for the writ petitioner to seek remedy or to seek relief in the form of civil suit. Stop. Next part, notwithstanding the factual position of the case, looking to the foundations as to why the writ petitioner has come before this court also relates to the apparent arbitrary action of the respondents in processing the permissions for grant of licensing for licenses and lease to the respondent number 11, inasmuch as it is noted from the, what annexure was that?
Annexure 19, page 90.
Page 68.
Page 90. The permission which was page 90. 90.
Comma.
Looking into the foundation that the petitions come before this court. The arbitrary action of respondent in processing the permission and grant of the license release was number 1, in as much as it is noted.
It's noted that by letter dated 25th April 2023, bracket annexure 19, writ petition, the process of grant of mining lease to respondent 11, whose name appears at serial number 2, appears to have been processed. Stop. Next paragraph. Mr. N. Khera on query submits that the writ petitioner will approach civil court within a period of 2 weeks from today to seek appropriate remedy. Stop. In review of the matter, this matter is disposed of with the direction that status quo shall be maintained with the permissions for the next 3 weeks to enable the writ petitioner to seek proper and appropriate remedy. Yes, you go. Yes, we are just protecting them for 3 weeks. Let them go and seek relief, because
These are old blocks, my lord, and grievance of my petitioner is that only small portion of land is overlapping, my lord.
Doesn't matter.
If it is not, because my lord, this is dated 26th April 2023, my lord. If it is processed also, and suppose some portion of the, because he is saying that some portion of lands is overlapping with.
See the whole permission will be for the entire block. Okay, you see the order will correct it. You can't. You see, the thing is that whatever it is, Mr. Advocate General, the thing is that everyone, it's the doctrine of fair trial. I mean, if a person has gone with a complaint to the authorities that this has happened, that this land is overlapping my land, and then one hand they say the time consuming to process to verify the land, and on the other hand you go ahead and start giving the permission. We'll correct it. You see the order later on.
Lordship, the respondent authorities be directed to give us copies of the documents which we may seek.
No. Then we'll have to make him. Then he has to appear. No, then we can't dispose it of here.
Respondent authorities, the government, because if we have to file it within 3 weeks, we will require their documents.
You have enough materials.
Item number 2.
Obliged, Lordship.
Then that's up to civil court. Yes. They can't have any objection, I think. Small application.
Worship, I am praying for instructions.
What instructions? Do you want to open the EVM machines?
No, it is not that.
Then?
Because they have served it on us, my lord. Let the petitioner at least have the knowledge that this is. So
Your challenge to the petition is to what? It's to what? It's an affidavit, correct?
On ground of subsisting contract.
Yes. Then.
So I'm not saying that I'm not objecting against. I'm just saying, my lord, it will be prudent on
Your objections on 9A only.
on 9A, my lord.
Correct. Then.
So no, what I'm only submitting, my lord, is that the petitioner is not aware of this application. It would be only prudent for me to.
When was it
inform
served
him.
to you?
Yesterday.
Then.
So
What time was it served to him?
Day before.
Day before.
Day before. Then what were you doing with your phone?
No, we could not.
From
my
that
lord,
time till
get the.
this morning.
No, it's not that, my lord. It is only that I want to show it to him and take it, my lord. It's not that I'm objecting. I understand that we are on a different footing.
See, you know why this application been filed?
Yes, I understand, my lord.
Why?
Because they have to return it, my lord, for the other, so that they can use it probably in the other elections.
Correct.
Yes.
It's a material thing.
Yes,
See, the
yes,
thing is that now those are just EVM machines.
Yes, my lord.
If you're not calling into question the VVPAT, or the even what is necessary? What do you want? What right do you have over them?
No, I am not objecting,
Then?
my lord. I am just saying that I want to inform the petitioner.
Tomorrow then.
My lord, I'm praying for Monday. Monday would be fine, my lord.
The only problem is, there's a certain timeline we have to follow.
We'll pass an order, doesn't matter. Yes, this is application number 3 in EP number 1. This is an application.
I'm praying for Monday, my lord, because it would be prudent for me to show it to him, my lord. Please.
Okay, we'll take it after.
Monday as the first item.
End of the board.
Monday, my lord.
This election matters, these things. End of
Which
the
is why,
board.
my lord, that if it was not an election matter, then I would have, my lord, submitted. Since it's an election matter. Monday, my lord,
Monday.
I'm as the
Take all of them Monday.
All of them.
Yeah.
obliged, Lordship.
3, 4, 5. Seven.
Your Worship, I have received a affidavit, Your Worship, and I'm praying to file rejoinder, Your Worship.
See, if you made false information, then it's very.
No, Your Worship, it's not a false, Your Worship.
Yes?
It's not a false allegation, Your Worship. It's the fact only. And they submitted, Your Worship, they submitted the register, and also, Your Worship, the register, they themselves, they fill their name, Your Worship, but there is no signature on Your Worship. They just put the name, Your Worship.
Okay. Mr. Nyota of the petition submits that he has received a copy of the affidavit filed by the respondent number what, Ms. Kharji? Number 4. He pays up to take instructions of the same in case the joint is necessary. Okay. When?
2 weeks, Your Worship.
Yes. He pays this matter for 2 weeks for rejoinder.
8. Sorry. Main list, item number 1.
Your Worship, I have received instruction from my client, Your Worship, that there is livelihood for settlement, Your Worship.
Is that correct, Mr. Molong? You have no idea.
No instruction. That was my instruction, Your Worship.
Doesn't matter, will admit it or what should we do?
Let
Because
it
now
come-
we are settled with the, you're both happy with the substantial questions of law, correct?
Yes.
Your point, your submission, they have gone in, and I think what we'll do is, you've got the copies now
I've got copies, my lord.
of the
Yes.
reframed substantial
Yes,
of law.
yes,
You have both got copies.
Yes, free my law code, yes.
Yes. So anyway, what we'll do is, you take instructions also. Mr. Nyota submits that there are talks of settlement going on. Stop. Though Mr. C.H. Molong is not aware of the same, he also prays me up to obtain instructions.
Oblige me.
Yes, this is matter after 4 weeks.
Oblige.
2.
But this is the matter, my lord, where from the records, my lord, it will be apparent that there was a malified intention on behalf of the state respondents, my lord, in not holding the DPC, my lord. So that is the contention in this.
But now it's held, it is held subsequently.
It has been held, my lord.
Then what will
but the
you do with this
question
one?
is, my lord, with respect to retrospective, my lord, because there'll be pay benefits.
That you can agitate in the other. You should have brought this by way of because reviewing the earlier one will have no. See, one thing, Mr. Nobby, reviewing the earlier one will just make it hold you the kichri.
No, my lord. The only thing is, my lord, with respect to the malified, my lord.
I understand. He said that it burned down.
That is their contention in the affidavit filed by them, that due to the fire which was way back, my lord, therefore they cannot comply to a certain notification. But the real reason which is borne out from the record, my lord, that was never placed before your lordship, my lord. If your lordships call for the records, my lord, the records will speak for itself. So, my lord,
now DPC rejected you also.
No, my lord.
Or not rejected? No, I mean the DPC has been held.
DPC has been held, and the DPC has recommended our appointment retrospectively from the date when we became eligible. The government, my lord, rejects
fine.
on that point on the ground that no, there's a certain notification which does not permit, my lord. Which does not permit. But the real ground of delay, my lord, was never placed before your lordship. That is the whole difficulty, my lord. If the records will...
in the other pending writ petition? Is that a pending one?
No, my lord.
But it's only one?
Only one, my lord.
Well, I'm confused with another case.
No, my lord. This is a disposed of matter, my lord. If your lordships call for the record will speak for itself.
Because in this case, your lordship, the document which they have annexed, that is the annexure, the notification dated 1998. We are not denying the existence of the notification, but we just stated that during the year 1998 there was fire and it has been, the office has been gutted down. For that reason, that particular notification was not available at that relevant point of time. That is our stand. So we are not denying the existence of the notifications. We are just saying that it was not available with the record.
No, what he said in the review, why he wants review?
But I say the DPC, my lord, the note placed before the DPC clearly states that the DPC was delayed on account of the fact that certain senior work charge employees have yet to be regularized. Therefore, my lord, there was a delay in the DPC. Now, my lord, the malified comes, my lord, into play in the event.
Which paragraph you said that?
My lord, page 63. Can you have page 65, my lord? Page 65. Page 63, my lord, is the notice for hold 2019. It says, my lord, DPC to be held on 11th November. So this is 6th November. Notice is issued.
Page 65.
Page 63, my lord, is the notice. 6th November. Notifying the date of DPC on 11th November, my lord. Now, page 64 is, my lord, the existing gradation list.
Yes.
Existing gradation list, my lord, kindly have serial number 1 to 9, my lord.
Yes.
Now, on the extreme right column, my lord, it says cannot be promoted because they are not yet regularized.
Yes.
Now, we are at serial number 10, 11 and 12, my lord.
Yes.
Now, my lord, kindly have the note at page 65 placed before the DPC, my lord. First 4 line, my lord, indicates the posts that are available for promotion. Now, the 5th line, my lord, which reads with, which starts with 8 May.
Yes, it may. I thought it said 8th May. It may. Okay.
It may be reported that DPC could not be held during the course of time as the office is anticipating the regularization of the senior LDA staff which are yet to be regularized by the government. So this is where the malified comes, my lord. Had these people been regularized, we would have missed the bus, my lord. Why? Because they do not hold the DPC when we became eligible in 2014. They decide to hold it in 2009. We are just fortunate enough that their case was never regularized. Therefore, we.
But what dates this letter?
This is, my lord, dated 11th of November. This is.
Where did you get it from?
My lord, again, I will read this along with page 63.
This is a continuation?
Yes, continuation, my lord. 63. 6th November.
6th November. No, where do you get the date 11 November? Where?
November, 11th
Where
November.
does it say 11 November in this letter? Where?
Yes. My lord, can you read again page CDs in the office? So, my lord, page 64 is the existing gradation list. And
no, but this is a brief note. It's not. It does not.
Yes, my lord. Brief
where's
note.
the date?
Brief note for the DPC, my lord. which was held on 11.
So 11, where was DPC 11?
Yes, my lord. Now the DPC is at page 65 or 66.
Okay.
Now this is the minutes of the DPC, my lord, at page 66. This is dated 11th
So
November.
by this you're promoted.
Yes, my lord. At the bottom it says from the date when we became eligible, my lord. And at page 67 is the revised gradation list.
So your prior, you eligible from which date? From which year?
2014, my lord. When we became eligible, my lord.
We're not entertained it now.
So, my lord, the question is malified, my lord. Malified intention.
No, it doesn't do malfunction because see at page 64, what does it say? It just remarks that promoted opposed UDA as a case line personnel for realization work charge period. That's all. So they're not considering the promotion of these people because they are still not regularized.
Yes, my lord.
And so what they've done, they've gone ahead and considered yours and given you promotion.
Page 65, my lord, it says it may be reported that the DPC could not be held during the course as the office anticipated the regularization of the
That's
senior
okay.
LDAs, my lord.
See, the thing is that they are trying to give you
It's a clear case of malified.
You be satisfied, we are dismissing this review. Yes. Heard Mr. Philemon Ongbi, counsel for the petitioner. By way of this review application, the petitioners have submitted that there has been a suppression of material facts with regard to the non-holding of the DPC, inasmuch as in the affidavit file.
Not at page
Filed by state respondent, your lordship. This page.
Where is given here? Affidavit filed by the state respondents. It has been this one, page 59. Where is that part?
Yes, sir.
Just give the paragraph.
Yes, well,
Where
I'll
is
just
this
read. I'll just read the relevant. Lord, page 59 is the affidavit. Your lordship will find at page 60, paragraph 7.
Yes.
That in reply to so and so, the writ petition is submitted that most of the office records and papers were destroyed in a fire which gutted the office of the state respondent somewhere in the month March 1998. As such, memorandum dated 1993 could not be traced, and due to oversight, directives issued by the above office memorandum was not observed and implemented in time.
Should be office memorandum 1990 instead of 1993. It should be 1998.
So this was the reason for the delay in holding the DPC, my lord, that there was a fire in 98.
As much as in para 7 of the affidavit filed in WPC number 250/2020, it has been stated that the DPC could not be held in view of the fact that the memorandum dated 6/3/1998.
Yes, 1998 years, lordship.
No, memorandum will be in 93 only. The memorandum dated 6/3/1993 could not be traced due to forest fire or due to a fire, which had directed that DPC should be held on an annual basis. Is that correct? Yes. Mr. Firmano, the learned counsel further submits that now it has been revealed that the non-holding of the DPC was not to the reason ascribed in the writ petition, but due to the fact that the respondents, in a brief note which is undated, have stated that the DPC could not be held as office anticipating the realization of senior LDA staff, which yet realized by the government. Stop. However, he submits by the DPC was held in 11th, the writ petitioners were accorded promotion on 11th. On 11, what's the date? 11/12/2019, the writ petitioners were accorded promotion to the post of UDA. So, what do you have to say, Mr. Abraham? Okay, Ms. Abraham submits that there has been no suppression of any material facts. And it's only that the memorandum was not available with the respondent at that point of time that was taken as a reason. He submits that the document shown at page 64 of the review application only indicates that certain persons could not be who are senior to the writ petitioners could not be promoted, could not be considered for promotion as the matter still lying with the concerned department for regularization. Stop. Next point, view the matter. The only point of contention is as to whether the writ petitioners have made out any ground for review of the order for grant of. Next point, consider view of the court, those there may be a certain anomaly as to the reason. The note which is spelled in lecture 5 is undated and the reason shown is not supported by any other materials. Stop. The gradation list of LDS as shown has clearly remarked that the person senior to writ petitioners cannot be considered for promotion has not been regularized. So for the reasons stated above, no case made out for review and the same is dismissed.
Then item number 3.
Lordship, in this case, after this inspection took
Where's the inquiry report?
The Ulysses inquiry
Instead
report.
of filing the inquiry report, he has
Who has filed?
Ulysses inquiry report I didn't get, but
just today, my lord.
Saying what?
Saying that he has received the salary for the month of January.
So what do you want now?
And some RTI is obtained by some third party, my lord.
Who?
Some RTI is also he has enclosed in his affidavit today that some RTI is obtained by some third party saying that the private respondent, who is also claiming to be the teacher.
Please don't eat, Mr. Sheikh.
No, has not, my lord, has not
Don't
attended.
chew anything in court.
That he has
You
not
can have
attended class.
Aram in the canteen. Yes.
So he has filed the affidavit saying that he has received some salary this year and that the private respondent is not entitled because he has not attended.
I this court absolutely cannot understand what submissions are being made. What salary? Whose salary?
Ulysses, the petitioner asked him this petition for the salary as because he was not written a salary. So thereafter, Ulysses, in between, this private respondents come in my petition and claiming to be he was the teacher in the same post. So
now you got salary. You said what inquiry report? Last time I want to bring inquiry report. What affidavit you file? God knows what.
Ulysses, last occasion, this state has inquired in the matters of the salary to the petitioner as well as this private respondents whatsoever thereof. So then one report was filed. Then I said this report whatsoever filed, it is not the inquiry report because it is the what's the report given by the secretary. So in the meantime, when this I was inquiring about the inquiry report, what the inquiry report actually is given to the government. So by this time I got my salary deposited in my account and I am getting my salary at the present stage. So matter is solved.
So to withdraw the application.
So in such situation, now regarding my salary, whatever dispute I was having, that's my salary I am getting. So now it has been restored from the month of January. So earlier salary, whatever is the area of it, prior to this, it is a managing committee. This is my salary, only this much. Then my petition will be infructuous, Your Lordship.
There is a standing order, Lordship. Court has disposed of the writ petition, my lord. That matter also is listed along with this writ petition, my lord. In that writ petition, my lord, while directing the respondents to release my salary till April 2018 till date, Lordship. Till date. That order is still standing, Lordship. Now, my lord, government's affidavit is very clear, my lord. When her rights came into existence in 2018, when the sum salary was directly, instead of crediting in my account, credited to her account. Prior to that, the salary was credited in my account. Then 2018, 5 months salary was credited in her account. Then I came to this court, and court has directed to release the salary afterwards in my name. Then he came to the court. Then government affidavit is very clear, my lord. Who are the SSA supported teacher, lordship? There are some boundaries given. If any person having that documents, they can be said they are the SSA teacher. My lord, kindly government affidavit. I am not saying that. Page 2.
1 second.
Now the court can scrutinize whether the petitioner or the respondent.
It's for what? For admission?
Part of
No, it
this
is for
order.
orders.
And posted for final hearing, lordship. Then.
I would pray, my lord, that if the inquiry would have come forth, it would be clear because.
Where's the inquiry? Who's the
inquiry
government?
is not submitted. my lord.
Inquiry, lordship. I don't know what inquiry and on what.
Who conducted inquiry?
State government. State has inquired in the matter.
Where's the inquiry report?
Seriously,
The report is here in the file. This is the report, correct?
That is not an inquiry, that was not a report.
Oh, yes, it's just some document. Where's the report?
Actually, that is not a report. The one which was not a report. But because this, the petitioner, the petitioner has filed a representation before the authority. Then the authority has asked for clarification. This is a clarification report. It's just a clarification.
Have you received it?
I've already given.
No, that was what was looked at on the last.
For a
occasion.
moment, kindly see the government's affidavit, lordship.
Then what about this? This is
As per
totally
the last
confusing.
order,
I
my
mean,
lord, the-
these cases from these areas, they need,
As per the last order, my lord, petitioner was required to file the inquiry report.
And inquiry also under what direction?
Where is it?
Yes, the government has inquired the matters, and then if they give.
Where's the inquiry report then? It's in your possession?
No, Your Lordship. It is with
Then
the government.
why do you undertake to produce it? Then why last time? See, court goes submissions of the learned advocates. Without your assistance, how will the court pass orders? So whatever you submit at the bar, the court accepts also. Because you expected to just bring the correct facts before the court. Now you see, we'll file it. You see, after Mr. Devnath, the counsel petitioner is allowed to bring on record inquiry report, conduct to clarify the matter. So bring the report or reports to clarify the matter.
I had thought you yes, because inquiry is conducted in process of this, even any copy to me. So
Then how do you know what was in the report? You last time he said that I'll bring the report, clarify the matter.
In fact, in the affidavit he has filed today in paragraph 1, he says, my lord,
I don't see any affidavit. What does he say?
he says, my copy of the report submitted by the state has been served upon me and I have gone to the state, said
So
report
this is the
and
report,
understood
this is
the-
the report.
Then?
That means there's repeat, and it is not the complete report. So I thought some other documents is there.
You have really succeeded in puncturing the wheels of justice. That would be. I mean, I don't know, Mr. Abdullah, how you can create such, what they call it, confusion, confounded.
For a moment, lordship, the government's affidavit, lordship.
See, Mr. Your duty is assist the court, make things simple in a chronological way. The facts will be placed in a certain way that helps the court. Like maybe I'm not as competent as you are to understand such complicated facts. So at least make it simple.
Here, this matters just when salary has been released. So that's why I brought this matters as the matters. Salary has been released now.
An affidavit will filed by Mr. Devnath bring on record a factum of release salary or in favor of his unfavored petitioner. What are submissions he make?
Final hearing,
Yes, Mr. S.A. Sheikh and the other respondents pray the matter with the final hearing. But it's a matter for hearing after 3 weeks.
Obliged.
Item number 4.
Hello.
Lordship, some respondent yet to be filed the affidavit, Lordship. So once all the respondent filed, then only I'll file the rejoinder. Respondent number 4, 5, and 6 they have filed on behalf of the state government also they have filed. Others have not filed.
This is one road only or many roads?
Only one road.
Dobasipara to Dalu.
Yes, Dewasipara to Dalu.
Yes, who's appearing?
Seriously, I am for the response number 8.
Lordship, it is
Your
there.
Lordship, state has filed the
Yeah,
affidavit.
Who hasn't filed? All filed. Who did say I haven't filed? You have not filed. You'll be filing.
I am for the response number 8, Your Lordship.
You filed.
I didn't file, Your Lordship.
Only states have filed.
And then what about who are you appearing for? Why? What affidavits needed to be filed?
This council and the state, they have filed.
No, no. What on what grounds? On what clarification? Whatever. Is it council?
Your Lordship, in this case,
So who are the concerned? Who are the answering respondents are to file?
National Highway.
The stand of the state is petitioners are not the actual landowners.
No, fine, fine. Who are the people? Who are the respondents who are required to file affidavits to help? To agitate the issue. That is.
National Highway.
That means one is State of Meghalaya file.
1 to 4.
1 to 4, correct. Then
5, 6 also filed.
Then now respondent number 5 struck off.
6.
Then
6 also
that
filed.
means now 7.
7 and 8.
7, 8. You haven't filed.
Your Lordship, I am for the response number 8. I am here, Your Lordship.
You're for. Wait 1 second. 7 is whom? You file. You file. No, 7 is India. 7, 8 and 9. 8 is Union of India, Mr. Dr. Mozika. Yes, amended. 8 is Union of India, Respondent Secretary, Ministry Road Transport and Highways. 9 is the NHIDCL. Who's appearing for that?
I am for NHIDCL.
Who's appearing for number 9?
MID.
That's number 10.
No, we have this amended. It is already corrected. We have
It's
already
amended up to 9. It is up to 9 is there.
See,
That's 9 only.
MID, other 9.
see, let's just listen, okay? 1 to 4 is state, okay? 5 has been struck off. Now what remains is 6 is the chief executive member of the Guardians Council. 7 also secretary to the executive committee, whatever. Then that is 6 and 7. 8 is Union of India. Okay. 9 is NHIDCL. That is Mr. Devnath, correct?
So you receive in my petition it is different.
And 10 is Meghalaya Institute of That's you. Yes,
Here-
take down.
here is
Take
difference.
down. Due to the correction of the cause title, certain certain confusions have arisen. Accordingly, it is noted that for the state respondents 1 to 4, MSR Colony is present. Respondent number 5 does not no longer exist, has been struck off. Next, for respondents, Garhills Council 6 and 7, Mr. S. Day with Mr. S. Deb is appearing. For the respondent number 8 in India, Mr. Dr. N. Mozika is appearing. For number 9, that is the National Highways Infrastructure Development Corporation Limited, in bracket NHIDCL, Mr. Devnath is present. And for respondent number 10, Meghalaya Institute of Governance, MS Savyan is present. That clears the issue. Now, how many have filed, how many are not filed?
9.
Now, all is
9
filed
and
is 1, 2, 4 have filed, 6 and 7 have filed. Correct. Now, stop. It is submitted that affidavits on behalf of has since been filed. Stop. Now who is to file affidavit? You are to file.
To file my affidavit.
Yes, Mr. Devnath, on behalf of you're filing. On behalf of 7B8, Dr. Mbozika submits that no instruction will be forthcoming. Stop. On behalf of number 9, Mr. Devnath needs time.
Yes, Your Lordship.
How much time?
3 weeks, Your Lordship.
Prays for 3 weeks' time to file affidavit. On behalf of number 10, no affidavit will be filing. On behalf of number 10, it is submitted by the council that no affidavit will be forthcoming.
Your Lordship, this state has filed the affidavit. Let us have the copy, Your Lordship, because
You do get it from me, sir. I'm not to act as a peon for you now. Accordingly, affidavits are awaited for your respondents number 8 and 9. Stop. 8 and 9. This is matter after 3 weeks for affidavits and for rejoinder, if any, from the petitioner.
Number 5. 5.
Yeah, Rosu is the same one.
Number 5 is also the same project, the same two reading of the code.
Same part.
National Highway 51. Here, my lord, the only issue that is with the state is that an offer has been made to petitioner. He has not replied to that, my lord. And apart from that, my lord, he's making extra construction, my lord, of his property, my lord. Claiming that extra payment should be made to the petitioner.
Have you filed affidavit at all here?
The only issue is that the payment, like the offer.
Have you filed affidavit or not?
No, they have not.
Then you file
For
affidavit.
the petitioner to respond to the offer.
Doesn't matter. If it doesn't respond, you note in the affidavit they have not responded. This MS for 126. 124. Then Mr. Dr. Mbozika 5, Devnath 6, and 7 is. Where's that? Council was here just now. 7, Mr. Gautam. You hear the matter number 7. What is this? Mr. Gautam is here number 7, correct? Your name appears also. Yes, number 7. God. Okay. MSR Koni on behalf of respondent 1, 2, 3, 1, 2, 4. Mr. Dr. Mbuzika on behalf of 5. Mr. Delmar and 6. And yes, CB Sawian for 7. Pray for and allow 3 weeks time to file affidavit. This is thereafter together with so and so.
Item number 6.
Should be filing the affidavit today, my lord.
Very good. This is submits that after we find the course of the day. List of the
I had a humble prayer for another 3 weeks for rejoinder, my lord. Petition is from Assam. Concerning the death at Nepal, lordship. Concerning the death of the petitioner's son at Nepal, I'm praying for a further 3 weeks time for rejoinder, my lord.
Why?
They are unable to come, my lord.
You're for the petitioner or you're for the respondent number?
Your Lordship, I'm for 1.
What's this lady doing this screen?
5,
No, my
7,
lord,
8, 9.
on behalf of the government of Assam,
Yes. You're appearing for government of Assam.
Yes, Lordship. I am paying for respondent 2.69.
You've already filed affidavit. Praise for further.
3 weeks, my lord.
These are filed to join the affidavit. Prayers allowed. This after 3 weeks. Yes. Yes. Yes, 3 weeks time after you.
Item number 8.
Okay.
Please, Your Lordship. My Lord, I've already filed the rejoinder affidavits to the affidavits of the state respondent and the district council as well. My matter may be posted for hearing after 3 weeks, my Lord.
3 weeks. Yes, rejoinder has since been filed by the petitioner. This is a matter for hearing in usual course after 3 weeks. Is that house near the river?
Yes.
9.
Yeah, please, Your Lordship. I filed a miscase, my Lord.
1 second, Mr. Hassan.
Why are you not giving up? Yes, sir, to recalling the order. My Lord, my
filing of the affidavit is closed, my lord, by order dated 28/4, my lord, 2023, my lord. So I filed the two miss case, my lord. The opportunity of filing the affidavit, my lord, by the private respondents, my lord. My lord, due to unavoidable circumstances, my lord, could not file the affidavit and could not pay the fine also, my lord. This honorable court has imposed, my lord.
That filing affidavit will be subject to rupees 1,000 cost,
yes,
as they, and you declined to do so.
My lord,
it is on at the bar said that we declined to pay and we're not filing affidavit.
My lord,
So I think this
my lord, there's a miscommunication, my lord. He has made a submission, but it's a miscommunication, my lord, happened, my lord. Due to some family difficulties, I went back to home, and there's a miscommunication between my colleagues, my lord. So, my lord, final chance may be given, my lord. Fine, my lord. Because
depends on the petitioner.
Should there's no cogent reasons for recalling the order.
Let's see what.
Para 5.
Yes, my lord. Para 5 and para 6, my lord. Lord,
it's not your fault also, which you've written there 5. It's the respondent's fault.
My lord, yes, my lord.
You have very fairly stated that the applicant states that the conducting counsel repeatedly seeking instructions, and regularly updating what the matter is, but then
my lord, this is one of that is also one of the ground, my lord. Para 6, my lord. Due to our fault, the conducting counsel, my lord. The fine, my lord.
This one comes subsequent, Mr. Hassan. Your very reason you made on number 5,
yes,
that you've tried your best as a counsel,
but
they refuse to cooperate. So does this kind of people deserve the consideration?
My lord, some documents that point of time could not get from the
respondents.
respondents.
These kind of people of your services.
My lord,
by your own statement, affidavit, you said that you've tried repeatedly, but you're not bothered updating them that the matter is serious in nature and to give priority, but they did not bother.
I humbly submit, my lord, a last opportunity may be given, my lord, because if last opportunity is given, my lord, no party is suffered, my lord. No prejudice is caused to any party, my lord, because their right is at stake, my lord.
Prejudice is caused to absence of justice.
Well, for the ends of justice, my lord, I humbly pray, my lord.
For the end of justice, for the end of justice. Yes, Miss Case number 68, 2023. Stop. This is an application dated 28/4/2023, passed in the connected writ application, whereby the filing of. This is not recalled the early order. Oh, okay. Closing the opportunity allowed to respond number 8 and 9 to file affidavit. Stop. Mr. S.K. Hassan submits that due to miscommunication on that day when he was not available, we put it on your shoulders. Submissions were made for this court that the fine was not to be paid, and that the respondent 8 and 9 were not filing the affidavit. Stop. He prays that some concession be given as the case of the petitioner needs to be put before this court. The point of view of the petitioner has to be put for this court to enable the proper adjudication. Next, Mr. Emmett Newpur, then counsel for the writ petitioner. You have objections?
Subject to payment of. Okay.
Yes. Has no objection to the prayer of the respondent applicant. In his view of the matter, in the interest of justice, the order 28/4/2023 recalled, the respondent is permitted to file after subject to payment of cost of ₹3,000 to the Meghalaya Legal Service Authority. After which we file within what?
My lord, there's two another item 10 also, my lord. Same case.
Lordship, in respect of.
1 second. Which is number 9 with me. Payment of cost of ₹3,000. After it, we file within 2 weeks. Yes.
Lordship,
Number 10.
in respect of the same item number 9. Lordship, there's respondent 5 and 7. They were supposed to file an affidavit and subject to payment of cost.
Now, Miss.
We have already paid the cost. We have received the documents. We will be filing.
You paid the cost. Okay, response 5 and 7 are allowed, but not in the main case. Not in the main case, in this case, in the main case, but in view of the order passed in this case of 342, response 8 and 9 allowed 2 times to file, allowed 2 weeks time to file affidavit subject to payment of cost of similar. So 2 weeks also granted to response number 5 and 7. Pay some more cost. You'll pay. Just like term, no? Similarly, 2 week further time granted to response 5 and 7 to file affidavit. Yes. List accordingly and so on. So. Yeah.
No further time will be allowed.
My lord will
No
file.
further time will be allowed.
Our affidavit is ready, my lord will file by
Court knows how to do that time.
2 weeks. 10 also. My lord, item 10 also same, my lord. I misfiled another miscase, my lord. My lord.
Then your counsel appeared that they said we're not paying costs, we're not filing affidavit.
My lord, it's our fault, my lord. Counsel, my lord. There's a miscommunication, my lord.
Which case 67.
Yes, my
same
lord.
thing.
My lord, same, my lord.
Right, same order. Yes. And here also, what about the other response? All filed.
Still filed, Lordship.
This case?
If I may submit, in regard to respondent 5 to 7, we're supposed to take fresh step. Lordship, another 2 days time we'll take fresh step upon 5 to 7.
So, this case, in view order passed also, 2 weeks time granted to file affidavit to which respondent number?
My lord, 9 and 10, my lord.
9 and 10. That's my son. Mr. ML pays for allowed further time to take stretch step on respondent's number 5 and 7. Yes, this accordingly also.
Hello,
11.
Condemnation for review, my lord.
Where's the petitioner?
My lord. So Paul's chamber is senior advocate K. Paul, sir.
We'll dismiss it. No one appears.
I'll enter appearance for respondent number 4.
What about the others?
Only one private respondent. I think GHDC. 1 to 3.
Yes, you're for number 4.
Yes, for 1, 2, and 3.
Referee officer.
No, 1, 2, and 3.
Aditullah Sheikh, great petitioner.
Where's the? Oh, where's the? Oh, sorry. I was having great petition. Number 4 is Ajitullah Sheikh.
Yes, great petitioner.
Yes, Mr. S.K. Hassan is under appearance today on behalf of respondent 4. So such a service complete. When do you want it? You want to file objections?
I'll file also.
5 days of delay. 5 days of
delay. My lord. It's okay, my lord.
Delay. This is a miscase for delay first.
My lord, that has been allowed on the last occasion.
Yes, my lord.
This is a matter of 2-3 weeks for objections by the respondents.
12. Item number 12.
12 is also a review.
Please, Lordship. This is a review petition where the private respondent not appearing to that effect. Order also has been passed and then condemnation application has been disposed of, allowing condoning the delay of 50 days, Lordship. Now this is for consideration of the main review petition. Here, my lord, what happened is...
Why do you want review? What ground?
Lordship, actually the initial poll order, it is reflected that on page 31. Yes, I like to. Here it is mentioned in that the hard board site for passing of this consensus order. It is clearly mentioned the fact of the case in detail, leading to filing of the case for Nokma of Tuchapara. Now, and it is present case of the.
Where reading?
Lordship, page 31, Lordship. No, just page 31 of my petition.
Where reading from?
Just
Para 3.
Second paragraph.
Second
Then
paragraph.
read it. Yes.
heard both sides for passing this consensus order. It is clearly mentioned the fact of the case in detail, leading to the filing of the case for Nokma of Tuchapara Akung. It is the present case of the petitioner and the opposite party and son-in-law and Nokma, daughter of existing Nokma, Srimati Kinti Seth Sangma, by side, tracking all of them according to the Chiran Dopachi, granting clan people succession of Nokma ship does not arise at this juncture, since the present Nokma Sri Kinti Sangma is still alive and performing all duties of Nokma ship and looking after me, Akung affairs as routine work of the interest of the clan. Now, my lord, against this order also we have filed we have filed a petition. I mean, we have filed an appeal before the CEM. The CEM also passed an order, and then against that order we have come to the court. Now the contention of the petitioner here, clearly stated on the basis of this order.
No, Mr. Is this a new fact that's been brought forth?
No, not new fact.
Then not new. Then what review?
No. Let me just.
We let you, but then you want review orders being passed by this court.
Yes,
on what grounds? Where's the ground for
my
review?
submission is.
Let us see your grounds where you made out in your review application.
Yes, I'll come to that.
No, we'll not come. We'll come to that first.
Yes.
Then after we get your grounds, then we'll see what lectures you have.
Yes. The thing is that the voter party, we have the ground I have mentioned.
Where's the ground?
Yes, 11, page 11 is started, and then yes, stated.
Yes.
That during the pendency of the case, White District JCTC Revenue 18 AC of 2000, the review petitioner neither engaged any counsel stroke lawyer to represent their case on their behalf, nor they were present at the time when the White Order dated 28/10/2016 was passed by the learned executive member.
This was not brought to notice of the court when the matter was heard.
Yes, Lordship.
It was brought.
It was not brought. I make a just barber submission, Your Lordship, but my submission also was recorded, of course.
See, review is limited to what, Mrs. Sama. You're aware of what is review. Review is not a fresh case opening up every case. Review is on certain very specific grounds.
Yes.
Where the court, you just heard earlier matter today. Even though there was something there, but think that's already a matter that already happened. You understand?
Yes, Lord.
So, on the basis of wrong submission or something also, whether it will warrant a review or not. Now, if some fact is new, or something was never placed for the court that changes the course of the entire, that has effect of changing the course of the entire order, then yes, that is the review will come. Otherwise, you file appeal. Why review?
Yes, appeal is there, but Lordship, I take sense because see, actually,
review.
I of course the petitioner.
Only in this court, I think that reviews is taken up and heard again. In other courts, review petition, heard review petitioner, no ground made out, dismissed. That was our fate when we were junior lawyers trying to review.
Yes, Lordship, but
before we could even stand up also, review is gone.
Lordship, I understand. Lordship,
yes.
The only thing is that on that day, during that time, I have brought this fact to the court, but Lordship also has pleased to record that also. It is recorded, my submission was recorded, of course.
Then
what's
there to review?
Now, thing is that since that order says that both the parties were present and their counsels was there, but in the record, Your Lordship, there was no counsel. They have not represented any counsel.
So that calls for review of the entire order. When the order is recorded, they were put present in the High Court order. In the order of this court, sure?
Lordship, 30.
In the order of this court.
In the order of the court also.
Sure, the
based on that only, yes, Lordship.
Sure.
Para? The page 50, para 8, Lordship. Because on the basis of that order, para 8, page 50 of my review petition, Lordship. May I read that? Because this order was passed on the basis of that.
Just read this. Read this very nicely. Read it loudly. Read it slowly. Read the para 8 that he's saying that. Read.
In consideration of the submission advanced by the learned counsel for the parties and the materials on record, this court firstly note that the order passed by the learned executive member, which is stated to be a consensus order, has protected the right of the petitioner for life without touching the right of the respondent number 4, who shall occupy the office thereafter. It is also noted the point that the order passed by the learned executive member was not by consensus, has not been assigned in any manner before the forum below, in the appeal or in affidavit filed before this court.
Then?
It is the fact, Lordship. We of course did not bring the fact on that day. We did
Then?
not even in the court of CEM and even before this court.
That's not consensus order. You never did that. Then you will not. There's no grounds for review without the review petitioner.
Allowed to withdraw, Your Lordship. I'll withdraw and file an appeal.
Yes, Mr. P. Sama for hearing something. Please I will to withdraw the review petition. Praise allowed, matter is closed on withdrawal. Stands disposed of.
13.
Nothing recorded in the order, these things recorded that both were heard.
13.
Yes.
Obliged.
This matter, my lord, affidavit is yet to be filed on behalf of the state, my lord.
What's the matter about?
Your Lordship, this is a case of reversion of the petitioner from the promoted post of LDA to the original
Small
post of
matter, why
LDA.
affidavit takes so long?
Well, this is the second round of litigation, my lord. This is basically, it was remanded back to the authority. So
Consider.
Your
They have
Lordship,
rejected.
the petitioner here also, she is on the verge of retirement.
When to retire?
Next year.
Next year's last time. This will have time to file affidavit.
This is one of the points of law only, my lord.
Yeah, further 3 weeks time, as split when AG is allowed for affidavit.
Okay.
This is the doubt.
14. 14.
May I please, Lordship, I'll be filing my affidavit in the course today.
Where's the birth certificate? Where's Mr. P.T. Sarma? You filed yesterday? I've been filed.
Yes, Lordship. Additional affidavit on 12 May.
Yes. 12 May, that's this Monday. What's the matter about?
Lordship, regarding pension matter, non-release of pension, because there are 2 dates, date of birth.
Now this one is shows.
As per now, my learned counsel has filed one affidavit.
59.
22. But as per the service record, as per school certificate, metric certificate, his age is 57. Date of birth is 1957.
But he is 59. But this is from from the competent authority. You can't toss it.
It is later on it was obtained in
2010.
2010, and that was.
Anyway, when you file your affidavit, will here post
Already
it? No. MSEV Pasa submits the affidavit number 4 will be filed in the course of the day. Stop. Petitioner, it's not final stop. It's also noted that affidavit being record the birth certificate has been filed on 12th of 12 finance. This is the matter after 4 weeks for hearing.
15.
Please, Your Lordship, I need some more time to file additional affidavit.
But if everything's settled, I mean, if the police against security, what is there?
Your Lordship, I have no
The
instructions.
construction of the school is going on. No more disruption.
No, I have no instructions.
If Synchron is not standing here, it means no disruption.
The senior also out of station, Your Lordship.
Yes, MS Panjam, no?
Yes, sir.
Please for has allowed 2 weeks for written validation affidavit.
Fine, Your
Just thereafter.
Hearing, supplementary list, item number 8.
The petitioner had filed a miscase, my lord.
Yes.
Here, my lord, the petitioner had filed a miscase stating that his salary has been stopped, my lord.
No, my lord, that has been verified. So, my lord, his salary has been released till the month of April this year, my lord, April 23. Now, this fact,
sought any instruction, my lord.
the council should verify from the petitioner. My lord.
Because I wanted instructions, and I said if we are
My lord,
coming.
here, my lord, only difficulty he expresses that, my lord, because there is a question of interdepartmental communication, my lord. So that.
But have you been paid or not?
Yes, my lord.
I have to seek instruction, my lord. I haven't received any instruction, my lord.
Okay, Mr. K.V. Varasaji, paying for state respondent submits on instructions that the writ petitioner's salary has been paid up to the month of April 2023.
Yes, my lord.
That is what he's saying.
Next, Mr. A.G. Movement, please be allowed to obtain necessary instructions from the writ petitioner. Just after 3 weeks.
All right, sir.
9.
This matter, we are trying to take down to 2 weeks.
Why?
This matter
Because
is urgent.
he's supposed to come. There's nothing urgent, my lord. This is pending
Yes,
since.
yes, my lord, because the list is going to expire in the month of June.
List is already expired, my lord.
No, it is not expired.
Well, this is supposed to come with some instructions, my lord. The nicknames.
My lord, as far as, my lord, kindly, my lord, take note, my lord. This is that case, my lord, where.
Yes, 6 to 4.
Yes, my lord. And my lord,
I remember
the-
6 to
4 to
my
6
lord-
and then 6 to
my
4.
lord,
4 to 6, 6 to 4.
My lord, the department, my lord, ought to have some service rules, my lord. The rules of recruitment rules that, my lord, they've not.
No,
shown,
no,
my
the
lord.
only thing in your favor, Mr. Barasaji, is that advertisement, okay,
My lord.
where originally 6 was revived again by them. That's all.
Yes. So, my lord, that.
And the other case is that one person is retired.
Resigned.
No, my lord.
Resigned.
Here, my lord, in the first case.
No, I'm just saying.
My lord.
So that's why they were to come with instructions.
So, my lord, only small submission, my lord, if this honorable court allows.
Because his chance will only accrue, my lord, in the present day scenario, my lord. Only if one is resigned, my lord, and the candidate ahead of in the waiting list,
You can't upon waiting list.
Well, that is our case, my lord.
No, no.
You can't upon you're upon select list only. So he's there in the select list, correct?
The waiting list, my lord.
No, my lord, kindly see.
Where is the law say you can't upon waiting list?
No, my lord, kindly see. There are, my lord, the DOPT guidelines is very clear, my lord.
No, wait, Mr. Prasad. Suppose, leaving aside your the thing is that now if one is resigned, where does it say you can't upon waiting list?
Supreme Court says, my lord. There are several decisions.
That decision is not before us, my lord.
Note down, give me the citation, it's very interesting. What citation is it? That you can't upon waiting list.
I have the
No,
copy.
it is not.
Then why would you keep a waiting list
Exactly,
in
my
the
lord.
first place?
That is the point.
No, waiting list is only for the purpose if, for example, the 4 candidates were selected, my lord, somebody does not join, my lord. But if somebody joins and
I'm interested in that. I'm not seeing the decision.
My lord,
somebody joins and resigns, my lord.
Does the recruitment rule say that, my lord?
See, it does not say that. In many cases, I think when in the police service also, which we know, what happens that suppose the merit list is there, person joins, goes for training, everything, he resigns. Then one person from the waiting list is taken
My
up.
lord, that is not permitted, my lord.
My lord,
If
this
somebody
is-
doesn't,
this is the DOP.
if somebody doesn't join, my lord, then only the waitlisted candidate will have some
This
right.
is the
my lord.
direction of the ministry, my lord. 2000 direction. DOPT guidelines, which is followed by even railway, my lord. It is
where's the
followed by all
judgment?
departments.
2 judgments are there. And there's many more, my lord.
This is Additional Advocate General, Assistant Advocate General. It's not by selection.
Yes, my lord.
It's not by competition, it's post Assistant Advocate General.
My lord, the next one also, but there are many others, my lord. I can play some more on this, my lord.
My lord, none of them are before this honorable court. My lord, the recruitment rules are not before this honorable court. Just merely on, my lord, can.
Wait.
1 second.
There are 3, my lord, of the second decision.
Of the second decision.
The last
first
page,
one.
We fail to understand the reasoning of the High Court in this regard when once the Para 3, the last page of the compilation. We fail to understand the reasoning of the High Court in this regard when once the selection process is complete and an appointment had been made, that process comes to an end. If any vacancy arises on the appointee having joined the post leaves the same, it must be treated as a fresh vacancy and fresh steps in accordance with the appropriate rules should be taken. In the view is fortified by the judgment of this court in the state of Punjab versus Raghubir Chand Sharma. Any temporary arrangement made during the interim will not entitle respondent to claim for. So there's a different aspect. My lord, the ratio is, my lord, once the candidates are appointed, my lord, the select list expires. The purpose of select list is served, my lord.
It cannot be, my lord. Select list has a duration of 1 year. What is that?
I can't answer this question. The Supreme Court
The
is very
panel
clear.
list for a period is for a period of 1 year, my lord.
I'll place some more decisions on this, my lord.
No, he's not on that also. He says that there were 6 posts advertised.
Yes.
So then, and then only 4 appointments were done, and so you reverted back to original advertisement to say that those that very advertisement that says that those applied earlier need not apply again. That means it's still governed by the earlier advertisement, and so if the earlier advertisements applied, he should be given a post. That's one part. The other part is that now the other second that's come up in this case is that one has resigned. So whether he'll be entitled to that post which is being vacated now. Now you say that that new post will involve new selection.
My lord, for that, my lord, he is number 2 in the wait list also, my lord. The first candidate, we will have the first right, my lord, even if we go by that.
The first candidate, my lord, I have the affidavit with me. The first candidate is the petitioner here. Is the second petitioner here.
There's nothing on record to that effect, my lord.
My lord, the first candidate, my lord, this I am making a submission. My lord, the very fact that he is not pursuing this case. What more, my lord? He is not interested in this case because he has already got a job in railway. He is posted in Guwahati. Otherwise, my lord, I would have been contesting for 2 petitioners. Here I am contesting for only 1 petitioner.
The thing is that now, what is the status of your advertisement if you've kept like sort of a rolling advertisement? You have to advertise again, but then you said that those people who advertised earlier on need not advertise because their application taken into consideration. And at the point of time, 6 posts were there, correct? So where does that leave you?
But my lord, the other aspect of the matter, my lord, even if he was in the main list, my lord, here is a case.
He was in the main list.
Wait.
Even if he was in the main list, my lord, because now it is also very clear, my lord, only somebody's name appearing in the select list does not give you any vested right, my lord.
That is a different limit of submission. The only concern is what is the status of your advertisement at a point of time. If that advertisement is adhered to, whether he would have been appointed by coming number, whatever is like this, he would have got appointment.
Yes.
That's his case. But by virtue of you advertise 6 posts and you appointed to 4, he's been deprived of employment.
The question,
that's all.
The other limb of argument will be, my lord, the employer always has a right to determine how many posts are to be filled up.
Can it be arbitrary, my lord? You 2007.
Wait, let's argue stereo, just one at a time. Yes.
So that is another angle of the matter, another aspect.
That you just bring up points as we go along. That's from what I can understand from your submissions.
So the three legal aspects are involved, my lord. Whether name appearing in the select list, whether it gives any vested right, my lord, number 1.
That is a foregone thing. That's not necessary. Name appearing in the select list doesn't mean that you have a claim appointment. Yes. Only the thing, your advertisement said 6.
The original advertisement, my lord.
Exactly. Then second advertisement said 4.
Reduced it to 4, my lord.
But then he said those people who applied earlier on need not think. So what is the status? That's the only thing this court wants to know.
Further, my
I
lord,
should have withdrawn the earlier advertisement.
Well, to give them a chance, my lord.
Further, my lord.
Earlier applicants.
No. Further, my lord.
What do you say?
But my lord,
it's not a run of the mill case because this kind of don't come also. What happens? Suppose you advertise for 10 posts of judicial magistrates, okay? Then for some reason doesn't come, then you issue an advertisement. And so those who applied earlier did not apply, and then another set of young lawyers apply.
Can also apply. They will also remain in the fray. But now the posts are reduced to 8, my lord.
Suddenly, you say we are appointing only 6.
The advertisement says the previous applicants will remain in the fray, but posts are reduced to 8, my lord. My lord, in my humble submission, there is no illegality in that, my lord.
Maybe he's right also.
But my lord, will kindly see that the corrigendum is issued. Corrigendum is issued, the post is increased to, my lord, 4 in the UR category. There is altogether 6. Thereafter, my lord, the result is published. So, my lord, once the result is published, can the selection committee again go back, my lord?
Is that the case?
Yes.
Seats increasing to 6.
Yes.
was issued, my lord.
First was 6, brought on to 4, then again to 6.
Yes.
By a
Then the result
corrigendum, it
is
was
out.
increased to 6, my lord.
Now, thereafter, my lord, arbitrarily the selection committee revisits that and cancels that, my lord, the
We'll give you
corrigendum.
one more chance to get instructions. You said you will get what they plan to do with that vacant post.
My lord, that is the first. Second is, my lord, even in the second, even if, my lord, the first in the first leg of argument the case doesn't stand, even in the second case, my lord, I am there in the waiting list. What is the purpose of the waiting list? But I would bank my case on the other, my lord, the first leg of argument.
Yes, matter was taken up today for hearing, but though the matter was heard at matters taken up today for hearing and heard at some length. Stop. However, on the question of the validity of the participant and the process, Dr. M. Mozika submits that he will be allowed to revert authorities to seek further instructions. Next paragraph, matter is a matter of 2 weeks, 3 weeks.
My lord, my only humble request, my lord, is that
Selectors will matter sub judice, my lord. Is absolutely.
Why you think someone else will come over your head and get appointed there?
But
that can be corrected. Yes.
Main list 26. Main list item 26.
my lord, this matter I am not ready to do. It is taken
Before the petitioner?
Yes, my lord.
Mr. Abraham is ready. What's the matter about? School?
My lord, this is that school issue, my lord.
No objection. This is a 21, 3 weeks on the plea of the counsel of the petitioner.
28.
His Lordship, this matter relates to removal from service from CRPS. He was an inspector in the CRPS. So there was allegation that he received the more than the amount he deserved for the travelling allowances. And subsequently, on his request, he refunded.
He had what? He had done what?
Travelling allowances, excess payment of travelling allowances. So he refunded that also, and the matter was closed. Subsequently, my lord, the departmental proceeding initiated against him, and final order was passed, a stoppage of a 2 years agreement. Thereafter, my lord, he was not happy, so he preferred appeal, and the appellate authority has set aside that one and imposed the major punishment of removal from service. So this is a brief case.
Any irregularity in the proceedings?
My lord, my grievance is, my lord, the quantum and as well as the punishment is not incommensurate with the misconduct.
What is the amount that of travelling allowance that he defalcated?
19,000 something, my lord. And
at what rank was he working?
He was the inspector. Inspector. So
it's a forging of documents, my lord. He has forged the documents in the office.
Those allegations
so that is why a serious note was taken. It's not only a matter of 19,000. But this matter may require some detailed hearing, my lord.
Not ready. DSG is overburdened also, too many cases, I think.
I don't want to press, therefore I spoke to him also. Maybe next week, if subject to lordship convenient or.
Next week, this court will be only for 3 or 4 days, yes.
Thereafter.
After 2 weeks. This is matter, this is a 22 matter. 4 weeks at the request of the counsel for the parties.
29.
Lordship, I am deeply apologize. Last time I could not do it because of my illness.
How are you now? You had an accident?
No, I had some gastro problems. So yesterday I came from Hyderabad.
Your Lordship,
Yes.
we have filed a miss case, Your Lordship. Miss case 70
For?
of 2023. On the same day the status quo was granted, the bank issued us a notice.
It's a general notice, Your Lordship, at page number 9.
9 Your
Of the?
Of the miss case, Your Lordship.
So general notice, so for surface proceedings, there's nothing to do with that. GST and all those things.
Your Lordship, if you would come to
Because they had
page 9, Your Lordship.
already
Yes.
initiated.
Third paragraph.
This is from the bank.
Bank Chief Manager. If you come to para 3, Your Lordship,
Yes.
notice is hereby given to MS Mabania Projects Private Limited, prohibiting and restraining it from recovering the debts due from its debtors and interest thereon, and all the debtors of so and so are hereby prohibited and restrained from making payment of the said debt or any part thereof or any interest thereon to the borrower or to any person whomsoever otherwise than to the undersigned. The debtors are hereby called upon and directed to make payment of any amount of due to MS Mabania Projects Private Limited to the undersigned. The payment made to the undersigned shall give valid discharge as if payment is made to the borrower. Your Lordship, after granting status quo, they had issued this notice. And we received this notice on the 11th.
That has been of this
11th
month.
of this month. Date it's written 3rd, but we received on 11, Your Lordship.
Order password goes on 3rd only.
3rd, same day, Your Lordship.
In the morning they had issued, from normal process. And Your Lordship, I'm sorry, Your Lordship, come to paragraph 2. It will be clear on that same notice. Paragraph 2.
Yes.
May I read, Lordship?
Yes.
Demand notice under section 13(2) of the Surface Act 2002 on 10/6/19 has been issued to the borrowers to the discharge its liabilities in full. The book debts and other receivables of the borrower are hypothecated charged with the bank as security and as such are secured assets of the bank. Your Lordship, I shall draw Your Lordship's attention. This particular project that is for which we have sanctioned the loan, it is a project finance. In their writ petition itself, they had annexed the sanction letter. From there, it is clear that 30 crores had been sanctioned for the entire projects. Now, the entire projects, that means there are shopping malls and other things are there. So all those rents are supposed to come to us. And we had just, by following the Surface Act, we had just a general notice that you do not, so the assets are not compromised. That's the spirit of this notice. Nothing to do with that.
But Lordship, they are directing the debtors to pay directly to the bank. For now, Lordship, I'm just praying for.
And they have already preferred Surface application before the DRT, and it's pending. We have already filed a reason. It's fixed for hearing.
We will close this petition. We'll close this petition.
Lordship, for now, I'm just praying that stay of the notice, and in the meantime, the writ petition may come up next week, Lordship, Monday, since Mr. Paul is not available.
No, your only case here is that your from the escrow account, instead of your statutory liabilities are being, instead of being paid to the for your fulfilling the statutory liabilities, the bank is recovering those amounts to
Was there loan recovery?
Yes, loan recovery to what's that word called? Yes, to like for whatever. Yes.
But Lordship, as per the escrow agreement, debt repayment is the last in the
Yes,
following order.
that's why this court had taken notice. That's why that was given. That's why it should be the last one, not to.
Lordship, in the Act, Lordship, if your Lordship takes up the Act, If your lordship has the Surface Act, I'll provide you.
No, it doesn't have that. What's the word? It's called. No, the only thing is as per the agreement that you
No, lordship, that's why I'm coming. Lordship. That's why I'm just, because that particular thing is demolished, because there is an amendment in the Surface Act as well as the DRT Act.
Right, you ought to service the loan. That is the word.
What it says, your lordship. Kindly see the Surface Act 26E.
Priority to secured creditors.
May I read? Notwithstanding anything contained in any other law for the time being in force, after the registration of secured assets, the debt due to any secured creditor shall be paid in priority over all other debts and all revenue, taxes, cess, and other rates payable to the central government or state government for local authority.
Let's see your agreement.
Yes, sir.
41 lordship of the writ petition.
The clearer one is in with my affidavit, lordship.
That is at page 42.
41 and 42.
Yes, see. As the cash flow shall be routed through designated accounts to be executed, all revenue receipts received the project will be deposited and so shall be deposited to the project as account of final settlement and so. Now shall be permitted under the financial schedule for the following order: taxes, statutory payments, that means your GST and everything, project expenses and fees due so and so, payment interest, debt service, and debt repayment.
Yes.
So, like, if we are bound, you mean to say this agreement is escrow agreement is not enforceable in law? It's illegal as per the surface side, as per the stipulation of the 26E.
No, I'm not on that, lordship.
Then,
lordship, what I am here to say is that so far, even the Supreme Court has upheld. I've got the judgments here. Only the EPF, where EPF is involved, your lordship knows, EPF is involved, then they get priority.
That precedence, yes.
Yes, sir. It's there. Now, so far the taxes, GST and other things, they come later. Because that's why this amendment has been brought.
Amendment came after 2016. Then you should have made a correction in the agreement.
No, it's not that we have to follow this because the moment this as in the escrow account, your lordship.
Wait 1 second.
In both DRT as well as Surface.
Interesting point. In the sense that, see, they were under the impression that once you entered the agreement, that if debt repayment was the last sequence for servicing of your loans, correct? And then the other statutory dues and the other requirements, payment to other creditors come before that. That means that you acted, in violation of the agreement at first, like servicing your debt. But now you brought this on record. I think let a senior come.
Hello, sure.
Yes.
That I.
But today I'm just bring stay of the set notice.
They already said there's nothing to notice.
No, there is nothing.
Because miscase.
Because if any order is
number
70, your lordship.
Where's the miscase? Okay. Miscase number 70/2023 in WC number 178/2022. This application has been filed by writ petitioner seeking stay notice dated 3/5/2023, whereby the bank has instructed the debtors and other entities to make payments of any amount due to the petitioner first to the bank, yes. Stop. Next paragraph. MSB Karanang submits that this notice was issued in spite of the order of this court dated 3/5/2023, which had directed that status quo be maintained by both the parties till this both petition. Now your submission will record. This is her submission.
One
yes.
point, small point. They had preferred application before the DRT, challenging the SURFACE application. And this notice is what it pertains to SURFACE application.
Yes,
SURFACE
I'll
visit.
note that. I'll
Now-
note down.
now
I'll note
if-
down that.
if he stays past, Lordship, then it will be a problem.
It's that, yes. Next paragraph. Mr. Datta submits that the notice in question is independent of the order in as much as it was issued no proceeding prior to knowledge of the court's order, and that's in the surface side proceedings.
Yes, Lordship.
Yes. He often takes that the orders of this court as ordered will be complied with. The orders as passed by school will be complied with the disposal of the writ petition. Stop.
So SURFACE is not untouched.
Accordingly, this application doesn't apply for consideration and is disposed of. Stop. Then list the main case for hearing on.
Monday, Your Lordship.
No, let it be on Thursday.
See, this court won't be available after Thursday. Thursday might not be here also.
They have to, then the next week, Thursday.
Next week, no, it won't be here for some time because of some engagements.
Monday.
He'll come only if you.
Tuesday, Lordship.
Listen on Tuesdays.
Tuesday, Lordship. Highly obliged. Highly obliged.
31.
May I please, Your Lordship? My Lord,
What
this
remains?
is no, my Lord, let me make one more attempt to persuade my Lord. My Lord, one aspect is very clear, that they are alleging that I have obtained this NIT by playing fraud. It is not.
We're not going to go there.
It is
already the bank guarantee.
Bank guarantee, not NIT. My Lord, exactly, my Lord. Now, my Lord, it is also an admitted fact, my Lord. I have taken a specific plea that certain amount of work has been completed by me, and for which I have raised the bill also, my Lord, and that has not been disputed. They say in their comment, both the union and the state says that we have no comments on that. So today they cannot turn around and raise an objection
Last
on
time,
that.
AG said immediately 5 meters of the road.
My Lord.
5 meters something, right?
My Lord, yes. No, 5 kilometers, my Lord.
5 kilometers.
5 kilometers of formation work, and culverts were done, my Lord. Five culverts, certain amount, my Lord. And I have raised a bill, my Lord. Raised a bill of 3 lakhs also, my Lord. It's pending. 3 crores, my Lord. Now, my Lord, when they have given me a termination, my Lord, I'm not going to that, but this is important, my Lord, according to my case, my Lord. Under which clause they have terminated me, my Lord? They have terminated me under clause 22, article 22, 23, my Lord. If they have terminated me under article 22, 23, then they have to follow by the same agreement also, and which says that if because of the default on the part of the contractor, my Lord, on the base of the contractor, if they have to terminate it, they are required to pay the unpaid amount, unbilled amount, which is pending before them.
Elsewhere.
My Lord.
The remedy lies elsewhere. There has been measurement done.
My Lord.
Then you have to examine the measurement books.
My
Lord. Then you have to call for the report of the junior engineer.
My Lord, it is
then
there.
They have to follow the report of your site engineer.
That is my point.
You expect this court to go into that?
My Lord, that
is measurement book.
May just direct them to follow as per the agreement, my Lord. That is the only thing. They can measure, my Lord, because the agreement itself provide, my Lord. Because they have terminated, because I'm not going even. Now
we're not touching a termination. The termination is gone.
Termination is gone. I cannot go back, my Lord.
Yes,
but
you cannot go back.
I cannot go back to that one. But
it's been retendered now also.
Yes. But to balance equity, my Lord, what lies before me, my Lord? My Lord may not relegate me to a civil court, my Lord, because it's a long process. I've come here. I've done my job. Okay, fine. Unfortunate things happen. I bow down. I'm not arguing anymore. I'm going back. But at least whatever I have done, acknowledge it. Please, your agreement says you take a measurement, and whatever it has to be paid, please pay to me. You want to give penalty?
Is there any penalty or forfeiture of any amounts due to any fraudulent practice in the agreement?
My Lord, there is as such nothing. But I am acceptable that also. BG you can deduct. This is all what I'm saying. 1 crores BG because my bill is 3 crores, my Lord. You deduct whatever, and
but if bank guarantee is fake, how would they implement it?
My Lord, they can as in the form of penalty also they can do, my Lord. Now, my Lord, they have already punished me, my Lord. They have terminated me. They have blacklisted me. Now what else they want to do? They want to forfeit all the amounts that have worked also, my lord. So this is only what I'm saying, is just for the balance of equity, my lord, and for the principle of natural justice, my lord. My lord has a power, my lord, to balance equity, because now
powers to be used in a proper manner.
My lord, because I don't want to go back, my lord, who has done the BG fake, who has not done. I don't want to go to that, and I don't want to go and argue also, my lord, forgery, because Supreme Court says a forgery is a person who has forged the document. They're saying I've submitted on.
Then that is more your case to go to civil court.
My lord, that's why
forged document.
Yes, my lord.
Whether the document now your head office said that it never issued his bank guarantee. If I correctly remember.
Yes, my lord. So I'm not even going to that one. And now there is other question also, my lord, because the BG is BG has been supplied by one particular officer. Another particular officer is certifying that this is a false BG. We have not supplied. I'm not even going to that one. I don't want to go to that. What I'm saying is that they have admitted 5 kilometers of work I have done. They have admitted, and now when they have called the new tender, my lord, they have minus that 5 kilometers which have been completed.
You sure about that?
Yes, my lord.
Materials to show that.
Yes, it can be ascertained. NIT.
Can ascertain. I mean, is it true that do they acknowledge the fact that you have done some preparatory works for the 5 kilometers or something, and which would have entailed, of course, expenditure?
My lord, as per instructions, my lord, it is there, my lord. I can bring the new NIT also, my lord. Fortunately, I don't have it here. I can bring that also, my lord. So what I'm praying is, my lord, otherwise I'll be put to irreparable loss, my lord. I'm not saying that
you or whoever you employed to do the work on your behalf.
My lord. So therefore, my lord, I bow down, my lord, only to balance the balance of equity, my lord. That's the only thing I'm asking, my lord.
Sir, I do not know, my lord. What was he is not entitled. Kindly, my lord, kindly see the order of development, order of termination, my lord. Well, lordship may kindly come to page 52 of our opinion opposition, my lord.
52.
My lord, this is section 4, my lord.
Number 3.
Well, page 52 of our opinion opposition by the state, my lord.
This is number 3.
Page 52.
Page
552, my lord.
Yes. Fraud and corrupt practices.
My lord.
Yes.
Now, these are the clauses, my lord, appropriate clauses. Under which, my lord, the bidders and their respective officers, employees, agents, and advisors shall observe the highest standard of ethics during the bidding process and subsequent to the issue of the LOA and during the subsistence of the agreement, notwithstanding anything to the contrary contained therein, or in a LOA or the agreement, the authority may reject a bid, withdraw the LOA, or terminate the agreement, as the case may be, without being liable in any manner whatsoever to the bidder, if it determines that the bidder directly or indirectly or through an agent, my lord, engaged in corrupt practice, fraudulent practice, coercive practice, undesirable practice, or restricted practice in the bidding process. In such an event, the authority shall be entitled to forfeit and appropriate the performance security, as the case may be, as damages, without prejudice to any other right or remedy that may be available to the authority under the bidding document and or the agreement.
So, it's earnest, the money is gone. Security deposit is gone.
My lord, it should be.
And it says, my lord,
now, see, Mr. Bhattacharya, just come again.
Yes,
it says that if there is a directly, indirectly, or through an agent engaged in corrupt practice, fraudulent practice, coercive practice, undesirable practice, or restrictive practice, in such event, the authority shall be entitled to forfeit and appropriate performance security, as the case may be, as damages. That means that security deposit is forfeited automatically.
Forfeited.
Now, what about the other ancillary facts?
My lord, that is a subject matter of dispute. We are not admitting anything. My lord, here, my lord.
Because the thing is that one thing, they are bound by the contract only. They have to go as per the terms of
definitely. Now, if he has to take seek remedy, my lord, if he has any claim, my lord, that has to be on the basis of the agreement, my lord. And he cannot get this agreement enforced.
Last time also, that's only thing that giving a chance to improve his case as all.
My lord. So, my lord, he cannot come and make out a civil suit here, my lord, cannot, my lord, get an order from this honorable court with regard to his claim, so far as work completed by him is concerned, my lord. It cannot be, my lord.
He is fearful of going to civil court because of the time.
time, my lord.
Well, that is, if the law prescribes that, my lord, I don't think, my lord, Rit Court would, my lord, tell him to bypass that, my lord. Would never, my lord.
Looking at the circumstances of the case, my lord, this is alternative remedy, my lord. It's not absolutely, my lord, debars.
We can't go to Whirlpool now.
My lord, exactly, my lord. Now, my lord, they are saying that they are not admitting. Kindly look at the affidavit in the paragraph, my lord.
Mr. Yubin last time could express his view also.
My
We're
lord,
not going to go.
my lord. My lord.
And you had specially sought instructions, if I correctly remember, on what you said that to
either to go a civil court or
yes,
my
to
lord,
advise my
yes,
client
my
to
lord.
know where we should withdraw this
my lord.
to take the course of civil remedy.
My lord, because
you're not pressing any of the leaves that you're pressing
yes.
in the prayer. Correct. That's
my lord,
it.
because they have given me instructions, my lord. Since we have done finally, so my lord,
instruction they give you.
My lord, we place our case and then my lord let the courts takes. And my lord, they are talking about the agreement, my lord. Agreement says that they have to give me a notice of at least 90 days, my lord. When they are going to terminate me,
will not go there.
They are going to terminate me, my lord.
It is wrong, my lord.
No. If you show the agreement.
There are two different provisions are there, my lord. What he is saying, that is wrong, my lord.
And even this, my lord, fraud. When what my learned senior is reading about a fraud, it says that during the bidding process.
No.
During the British.
No, thereafter.
And during the bidding process and thereafter, my lord, and they are saying that forfeit. Now suppose if I have let's assume that I have played fraud and whatever and I've done, but they are acknowledging that certain amount of work I have done. They have already forfeited my earnest amount. They are saying that BG amount also they are supposed to. What is the BG for? BG is in case I cannot for any other circumstances, for any conditions that I cannot.
In cash bank guarantee.
A bank guarantee, my lord, is a false one, my lord. What, my lord, do we have to basically?
The bill is lying with them. The bill is lying with them.
See the bank guarantee itself. It's my lord. So what is the question of I forfeit my BG?
My lord, what I mean to say is, my lord, the bill is lying with them. 3 crores of bill, my lord. They can forfeit the equivalent amount of my BG. I'm saying that I'm ready to go that extent also, my lord.
What he has given us to forfeit, my lord.
No, my bill.
BG himself is the courts, my
no,
lord.
they have, my lord, can you look at this? The writ petitioner, the affirmation made in paragraph 10 of the writ petition, the answering deponent states that the same requires no comment. And what is my paragraph 10, my lord? Paragraph 10 and 11, my lord. Paragraph 10, my lord. I say that as on 13/5/2022, the petitioner has already completed the formation cutting artwork for 3 kilometers out of 6 kilometers. 6 numbers of RCC culverts have already been completed out of 50 numbers, and 1 kilometer of drain have already been completed out of the total 6 kilometers, which means the work was in full swing, and according to the bill amounting to rupees 3,25,72,000 was submitted.
Have you been
yes,
advanced in the running bills? Have you been
running bills?
Advanced?
No.
Have you been given advance to start the work at all? Not 1 rupee also?
No, my lord. Running bill.
Sure.
No running bills.
My lord, lordship is putting in certain question which he himself has not pleaded, my lord. He should have. He wanted those relief, my lord, should have come with those. Now, in absence of that, my lord, I do not know. And this paragraph, my lord, which way it is relevant to determination of the controversy.
Mr. Yobin, you want this court to enter an exercise of looking at measurement books.
No, my lord. No,
then
I'm not asking.
Then you're saying give a direction to them to go and measure the work that you have done, and after measuring the work, subtract you keep that security deposit, the performance guarantee. That because of your whatever infraction, then after that, then you pay the money to you. I mean,
my lord, the very paragraph which he has read out.
Can we put such a burden on the shoulder,
my lord,
for your actions,
my lord? The admitted on the records. The admitted fact is that
we're not going to reports. We're not going to go there because that's why I'm saying go and file a civil suit,
my lord.
Then you can make all the prayers there for measurement, for inspection. You can go for local inspection.
My God, that will take a lot of time.
That's not an excuse to avoid.
I've gone back to Arunachal, my lord. It will take a lot of time for me, my lord. The course of action is here. Agreements are here, my lord. And my lord, there are cases, my lord, where the honourable court, my lord, has exercised power under rate 226, and on the basis when it is an admitted factor, my lord.
On a basis admitted fact that at the initial bidding itself that the contract is given a fake bank guarantee.
No, my lord, no.
If that's
That
the
is
case, you showed
subsequent.
authority.
Even
You
LOA,
showed
my lord,
order. You showed take the
my lord,
order.
letter of acceptance was given to me in the month of November 2021. BG was of January 2022, my lord.
My lord, in his cause he has admitted everything, but then just say it, my lord, try to escape by saying that my agent has done it. That is the only contention he has taken.
Exactly.
Now, my lord, this paragraph, kindly see.
Come to your prayers. Okay.
Yes, my lord. This paragraph and the paragraph 10.
Come to your prayer. Come to your prayer. Okay.
Paragraph 3 is totally contradictory to his paragraph 10, my lord.
My lord, this is I am praying for submitting a fresh bank guarantee, that's gone. But then there are other projects, my lord, where they allowed. I can prove it also. They said it's a fake. For the interest of justice, I give you a certain time. You furnish. They were very hurry in terminating me for whatever reason. I will not go into that. But then, my lord,
you cannot go into that
yes,
also. It's already been written there now. Anyway,
now, further they will respond to take a joint measurement.
Orders.
My lord, my lord.
Thank you.
My lord.
33.
You've tried your best, Mr. Human. I give you that. It's a very difficult case. So that's what advocacy should do. That is what an advocate should do. Yes. What is point number 3? No one's there. Yes.
Please, Your Lordship. Your Lordship, this matter pertains to claim of family pension, Your Lordship, unmarried daughter. Your Lordship, earlier occasion also we have approached this Honourable Court, Your Lordship. However, the matter was withdrawn because we had received a communication wherein the office of the respondent had treated the impugned letter as cancelled and had asked for us to submit fresh documents, Your Lordship. However, Your Lordship, that was in the year 2020, Your Lordship. We had submitted in the year 2021. Till date, Your Lordship, we have not received our family pension, Your Lordship. The ground for that, Your
Where's
Lordship,
the earlier
we are
order?
stating earlier order, Your
Oh,
Lordship.
withdrawal, this doesn't matter.
Your Lordship,
Oh,
earlier
where's the
orders-
communication they said that to submit fresh?
That is at page 28, Your Lordship.
20?
The matter was heard, Your Lordship. They were.
No, where he said that, dear?
instruction.
Where he says, please submit fresh documents.
That
please
is
submit.
page 28, Your Lordship.
Children family pension.
The type copy is page 28.
Yes. Read it. Where does this say?
Okay, Your Lordship. Reference to our letter dated 26 October 2017 treated as cancelled. That was the impugned letter under challenge in the previous writ petition. It is to inform you that following documents are required for processing children family pension case in your favor.
So why is not been processed?
Your Lordship, they are saying that they had sent the documents for verification, but just because there is no seal, now they are waiting for that, Your Lordship. It's been 1 year.
Dr. Mozika, have you filed affidavit?
We have filed.
What do you say in your affidavit?
Well, initially what we said, my lord, that in the service records, the name of the petitioner is not mentioned, my lord. Some wife and some other children's names are mentioned in this.
That was gone in 2 years.
That was heard.
Now, after that, they've submitted. Now, whatever documents were submitted with them, we wrote for verification to Mizoram, my lord, from the office. Those documents we received. We received a reply without any seal of the office, my lord. Then we have written back to them. But bills matter come after some time. Well, I'll talk to the department.
See, the thing is that
if
it's only on technicality. See this annexure 12 of your affidavit.
My lord.
Whether the letter has been sent by your office. That's all. To the OC in charge.
Without any office seal and date.
Let them obtain instructions. Mr.
If there is any further
Mozika-
because the affidavit is
yes,
for
Dr.
filed in the month
Mozika
of-
submits that you first record that like this in the course of hearing it appears that the process for consideration of payment pension to the writ petitioner was due to the fact that the letters had been issued from the authorities in Mizoram to ascertain the genuineness of the certificate has not been signed. Stop. Dr. Mozika, at this stage, submits that as the respondent had sought clarification as to whether the said certificates were issued from the particular office, he may be permitted to seek instructions. Yes. Lists this matter after 3 weeks.
34.
May it please your lordship. Your lordship, here the petitioner is the legally wedded wife, your lordship, of late Atul C. Marak, your lordship, who expired on 13/3/2022. Of ex-MLA, your lordship, Atul C. Marak.
Atul Marak.
Yes, your lordship. So, your lordship, what happened was when the petitioner approached the concerned authority, your lordship, which is respondent number 3, for the issuance of the death certificate, fresh death certificate, your lordship, it was denied on the ground that it was already issued to respondent number 5, your lordship, who is not a legally wedded wife. So, your lordship, the petitioner submitted a representation, your lordship, dated 17/11/2022, your lordship, which is at page 17, your lordship, annexure 2, to the respondent number 3, your lordship, for the issuance of death certificate.
Yes.
As she is the legally wedded wife and there is no bar in the registration of...
Her name is, this is the petitioner, Binon.
Yes, your lordship.
Bina Roy. Yes.
So, your lordship, no response was forthcoming from the respondent number 3, your lordship, for the issuance of death certificate. So, your lordship, this, the petitioner submitted another representation, your lordship, to the respondent number 2, which was recently struck off, your lordship, by this honorable...
Number 2 is whom?
They have stated that there is no such office in their in Shillong Municipal, your lordship.
Okay.
Yes, your lordship. So we have received one letter, your lordship, which is 7th February 2023, which is at annexure 4, your lordship. Here they have stated, your lordship.
Annexure 4 is your letter again.
Yes, your lordship.
Yes.
Annexure 4 is my letter. So they have replied to this letter stating that since...
Where's the reply?
It's in page 22, your lordship, annexure 5A.
Yes.
They have stated since mutual agreement between two parties cannot be reached and legality
What is
cannot
wrong
be
with that
decided
fellow?
by the registrar, your lordship, kindly direct the applicant to obtain the order from the concerned court, your lordship. So that
Yes.
is the only application they have.
Have you got a copy of death certificate?
No, your lordship. I have
Death-
gotten, but my name was not there, your lordship, in the as a wife, your lordship. The name
Death
of the respondent
certificate.
number 5 was there, your lordship. Whereas I have provided
Where's your marriage certificate?
marriage certificate is at
The marriage certificate is in
page number 12, your lordship, annexure 1. Type copy is at page number 17, your lordship, annexure. Sorry, your lordship, it's page number 15, your lordship, annexure 1A. That is the type copy of the marriage certificate, your lordship.
This is
deed of marriage, not marriage certificate.
It is the seal and sign of the registrar is there, your lordship. The seal and sign of the registrar.
what kind of deed of marriage is this? It's under what provision? Are you the first wife?
Yes, your lordship, I'm the first wife. Your lordship.
It's very strange. The first time I've seen deed of marriage. And it's registered also.
This is in Guwahati, your lordship. Guwahati.
Oh, it's just a affidavit.
Just an affidavit, deed of marriage, not registered, but
No, no.
just
Registered. See, deputy registrar.
Sub-registrar,
Got it, yes.
seal is there, your lordship. Joint registrar.
We see soon. They didn't marry in church.
Your lordship, we were legally married in court, your lordship.
I mean, they were not married. There's no church certificate. Which year was this in?
1976.
76.
Yes, sir, 1976, your lordship.
76.
1976.
76, 76. Yes. 76, huh? Where's the death certificate?
Death certificate.
Affidavit.
It's annexed in the affidavit of the respondent number 5, Your Lordship. It's at page 22, Your Lordship, Annex 11 of the affidavit of the respondent number 5, Your Lordship. Page 11, page 22, Your Lordship, Annex 11. 22, Your Lordship.
Then, were you staying with the deceased at the time of his death? No.
No, Your Lordship, I was not.
That is why death certificate was issued. Shown as a wife.
But Your Lordship, in the affidavit of respondent number.
What about now? What about the assets, debts, and liabilities of the deceased? Have they already taken it? Already
No,
taken
Your
it?
Lordship,
No,
Your
it should
Lordship.
be pending
It
before
is
the
pending
court.
before the court, Your Lordship.
Which court?
District
The law
Council, Your
court.
Lordship.
Then you have to file an objection there.
We have already filed an objection, Your Lordship.
Then why of this? You come for what
We
here?
are only coming for the issuance of death certificate, Your Lordship, which was
You
issued
give them
in
a
the-
certificate.
Lordship, may I submit,
Because,
Your
Your
Lordship?
Lordship, Your Lordship, in their affidavit, Your Lordship.
Now they're seeking to change the name of the wife in the death certificate.
No, that cannot be.
Your Lordship, in the affidavit, they have clearly stated in page number 35.
No,
Your
that
Lordship.
doesn't have to go by evidence.
May
You have to go by evidence in the sense that you have to bring whoever. You see, you're contesting to the succession.
Yes.
Now it's based on the fact that you were the first wife, correct?
Yes, Your Lordship.
And then the respondent number 3 is the subsequent wife. Then they have to prove by way of evidence.
Lordship, may I just submit, Lordship, because
Yes,
it is
please.
the fact, because at the time annexure 9 and 10 I have mentioned, because they here at the time of death she admitted.
Doesn't matter.
This is
Whatever
what-
it is, if she's a legally wedded first wife, she'll be
But
entitled
she
to
has
something.
decided. She has decided since
Doesn't
from
matter.
20 years back.
Divorce was not obtained from me, Your Lordship, from the petitioner.
20
Your
years
Lordship.
back, she has decided, and then
In fact,
later.
the marriage is
Let
illegal,
me
Your
just
Lordship.
come, because I have
was
never
not
disturbed her
within
when
the
you were
jurisdiction of
submitting.
this honorable-
You should give an
Apologies.
fair an opportunity, because when he was making submission, I never disturbed her. I allow her to say whatever she want to say.
She's
Now-
already apologized, so enough. Yes.
Lordship, see what
Try to
my-
paint yourself as a saint all the time.
the fact is that there is no illegality in issuing the death certificate in my favor, because in the annexure 9 and 10 is very clear. I was there in the hospital, and I have even applied for the application. Indeed, the record speaks. Even the dead body was handing over the dead body to the. They even reflected that that I'm the
Which
wife.
court is this pending?
There is no cases no pending in the court regarding this, because that
No, regarding the debt and securities.
debt and securities.
District Council, Your Lordship.
Not
In
district
Shillong.
council, not district council. It is for pension. She is coming for pension. The Emily, ex-Emily, it is in the office of the assembly, the secretary, the assembly, Meghalaya Legislative Assembly, Lordship.
See, death certificate by showing the name is not conclusive proof that the entitlements of the petitioner will be extinguished. Okay, doesn't mean that.
But here that letter.
You are saying yes.
This letter, Lordship, filed by this one, Annex 20, page 22 of she has already, which she has reflected. They said now.
Issue 22 of what?
Page 22. She said there is a letter, and she has to approach the competent court to establish her
You
right.
can't settle the matter between you. Give us something.
No, we are not on that, Your Lordship, because
No, I mean these kind of things. See, if you are both wives of the deceased person, so that he may rest in peace, also, can't you come to settlement?
it is up to them. I have nothing to say on that, because if the parties are
Are
coming
you
in
able
for-
to go for mediation?
Your Lordship, I'm here only for the issuance of death certificate, Your Lordship.
No, I mean, see, it's not issue that for here, you're here for the debts and securities, whatever. You want a part of his estate, right? Another thing.
if they want to agree, I have no problem. I will instruct my this respondent also. They can do that well and good, instead of coming to court and fighting. They will unnecessarily waste of time.
Will take a long time.
Yes, Your Lordship.
If they can settle the both party, then.
What do you say, Mr. Nongri?
Lord, kindly have page 23 of my affidavit.
Let them try to mediate.
This is pending before the additional district civil judge, which is Pura.
Where is that?
Succession. Page 23 of my affidavit. Where is one?
Succession also we got it, Lordship. Now they are still challenging that also.
This is a succession filed by the petitioner.
They already got succession certificate also?
We got such succession also.
Where's that?
Revocation also, Your Lordship.
We have not enclosed it, but we already got it, Lordship. Now they are filing that for revocation in the court. They have filed it in
This red court, there's nothing that this red court can do.
Exactly. That's why is this red court saying go for mediation?
Yes, ma'am. As far as we are concerned, if they surrender the original, we can also go through a new one. Now that is not possible. So the only way is they have to, several remedies are there.
The matter is pending. That means your succession suit is on hold now.
Yes, it is with me. That is still pending.
Yes.
No order has been passed.
Take down. We'll send for mediation. Who can be a mediator in Tura?
Tura, I think, is because one petitioner, that respondent is here in Shillong only. So from Shillong also is possible. I suggest from Shillong.
Yes, Your Lordship. The petition is in Tura, Your Lordship.
How did it come for mediation then once in Tura?
No, on the earlier occasion there was a mediation between the the Atur and the petitioner, the husband and wife, because for property only. That case come before this court only, but at the time the case was pending, he expired. That's why the case was already just disposed of. There was a property dispute between the husband and wife. She was the earlier petition and was want to take hold of the property, and the husband challenged that one. And there was a mediation actually. Honorable Justice D. Dingdo has as a mediator, he has passed an order. Both of them has settled the matter. He has signed it also. And
so you've got portion of property also.
Your Lordship, at that time.
And that mediation, against the mediation also they come.
So I'm not aware of that case, Your Lordship.
It is there in the report.
She's very smart. She's very smart. She's not giving anything away.
At the time when it was already settled, the property was already settled, but they were still agreed with the mediation also. Both of them signed also.
You didn't sign.
I also signed. She also signed, but still.
Then that means, as per the mediation, you have divided the property.
Divided the property. It is on record.
She's already got her share.
Both of them, because some portion of land she also got, I also got it, and but still she won that some portion of land. They said that something she filed it application.
Just bring a mediation agreement on record.
Definitely, I can bring if Lordship give me a time only.
You bring it.
Yes, Lordship.
Let's have a 3 weeks. Very interesting case.
Within 1
for remediation.
Yes, I think. But it is there, Lordship. I will bring Lordship.
This is matter for further hearing after 3 weeks. Yes, with the PD Sangma to bring on record the mediation agreement.
I will just file it in the affidavit. This is the one.
To bring on record the mediation agreement arrived at between the parties.
Lordship.
Very strange case. But very rich, I think, this person who died.
He's ex-MLA. She has got 2-3 wives, that's why there's a problem.
So as good, it's still in memory. Usually when people die, within 1 week, he forgets. At least his name being remembered when we're fighting over the properties. Yes.
Much less, Lordship.
Right,